Friends, in this presentation, we will be discussing one of the recent developments which has occurred in the EU region, which is the publication of digital omnibus proposal on 19th November 2025. This has now been released for discussion and further processing. It may take a little time for these proposals to become effective, but since it contains some 16 amendments to GDPR, we feel it is necessary for us to take a look at this and understand what these amendments mean for GDPR compliance. Now, most of these amendments are technical in nature, may not change the underlying law. Now, one of the first amendments which is recognized here is about the definition of personal data. Normally, personal data is considered as any data about an identifiable individual. And in the GDPR context, any single data element which was about an individual was also considered as personal data. This was similar to the HIPAA concept where there was what is called identifiers. And every identifier was considered automatically as personal data. But now things have been clarified here, brought more into tune with our Indian concept. Now, what the GDPR amendment has said is that if there is a set of personal data and one data controller is able to identify that, it is personal data in his hands. But if the same data, if in the hands of another person is not identifiable to an individual, then it is not considered personal data in the hands of the second person, which means that the status of data as personal or not depends upon the knowledge of the person who is holding that data and his ability to identify the person with the particular data set. This is similar to what was being told in our theory of data, hypothesis number 1, which stated that data is in the beholder's eyes, created by technology and interpreted by humans. This was covered in our Guardians of Privacy book, and you may refer to that. Now, what this means is now the concept of identifier as a personal data goes into the background. For any data to be considered personal data, with whatever couple of elements are available together, it should be possible to identify a particular individual. So this facilitates transfer of data from one entity to another entity with pseudonymization, anonymization, and even as a limited set by removing some of the identity elements so that in the hands of the next person, this particular data may not be considered as personal data. Now, amendment number 2 relates to the purpose limitation. Normally, when data is processed for a specific purpose, if it has to be used for any incidental purpose, it is not permitted. And there were certain conditions attached under Article 6, subsection 4 as prerequisites for processing of personal data collected for one purpose in the ancillary usage context. Now, that part has been said as not necessary, which means that it has become easier to process personal data collected for a particular purpose for an ancillary purpose. Now, amendment number 3, a new addition has been made to the processing of special category of personal data under a GDPR, particularly in the context of AI training and processing of biometric data. Now, such data can be used provided the organization, which is the controller, is able to provide appropriate organizational and technical measures to avoid that collection and processing of special categories of personal data does not cause a harm to the data principles or the data subjects. Now, Amendment 4, there are certain provisions of the rights of data principal, data subject, where when they exercise a right to information, then the organization or the controller was not expected to charge any fees for such release of data. Now, what has been amended is that this concept of free data would not be available when the data subject abuses the rights conferred by this regulation for purposes other than the protection of their data. That is, if the data subject is exercising his right to information with for a purpose which is not to protect his data, but for some other purpose, which may be litigation or something like that, then it is okay for the controller to either charge a reasonable fee or even refuse to provide that information. However, in such cases, the controller has the responsibility to demonstrate that the request was not connected with any reasonable grounds for securing the data or his privacy interest. So it was something for ulterior purposes, and therefore we are exercising the right to charge or right to refuse. This seems to be somewhat similar to the Indian DPDPA context, where certain duties are imposed on the data principles as part of the rights also. Now, amendment number 5 talks about certain information to be provided in the privacy notice. When a privacy notice is given, there are certain informations to be provided, like the purpose, the details of processors, recipients of the data, retention period, etc. Now, if such data was already available with the data subject, then it was exempted from the privacy notice to be included. That is, in the privacy notice, to include this data was not necessary if this data is considered as already available with the data subject. Now, this exemption now will not be available in cases where the transmission is a disclosure outside the data controller, may involve transfer to the third country, it's a cross-border transfer, or it may involve automated decision making, or it involves high risk to the data subject. So in such cases, this exemption of no need to provide the information to the data subject along with the consent request is actually not available. Now, amendment 6. Now, this is regarding again Article 13, providing the information. Provision of information such as this purpose, retention, etc., is also exempt when the processing is required for scientific research purposes, in case the provision of information would involve a disproportionate effort. What these two things have done is, at the time of drafting the privacy request, in some context where the data principal is already having the information, you can manage without giving too many details. Now, Amendment 7 relates to Article 22, which is related to automated decision making. Now, what this says is a decision which produces legal effects for a data subject which is like causing harm, may be based solely on automated processing only in certain cases, such as when it is considered necessary for the performance of a contract and is otherwise authorized by a separate law. That is, use of automated processing needs to be substantiated with a reasoning. This is what in BGPSI AI we have said that one of the implementation specification is responsible deployment. That is, the deployer has to substantiate why he needs to use AI and why he cannot do without it. Same way here, it says that only if it is necessary for entering into for use of automated decision making, it should be used. Now, Amendment 8 relates to data breach notification. Now, the time for reporting has been increased from 72 hours to 96 hours. And also, the EU is trying to provide a single entry reporting mechanism so that all the states, member states will be able to report in one single place. Now, amendment number 9 relates to Article 35 DPI regarding DPIA. Earlier, the supervisory authority was supposed to prepare a list of operations for which DPIA was necessary. Now, instead of the supervisory authority, it will be done by the board so that there will be some common list for the entire EU region. A common template and a common methodology also will be developed instead of each country's supervisory authority developing their own list of DPIA. Now, Amendment 10 is a new article which has been added, which says that standard for pseudonymization may be determined by the Commission and distributed as a requirement to all the member states. And while giving that standard, they will assess the state of art of available techniques and develop appropriate criteria, including the re-identification possibilities. Then these amendments 11, 12, 13, 14 relate to removal of some of the existing sections or articles, and it's a replacement as per other sections, other articles. Now, amendment number 15 is a terminal equipment related things, which is a new article. Now, actually, 3 articles 88 A, B, C have been introduced. Basically, what it addresses is when a terminal equipment like an IoT stores personal data, or there is a gaining of access of personal data which is already stored, then consent is required for accessing such data or storing such data. There is an exception, of course, for law enforcement, judicial environment requirement, and or by any other law. Now, in case such collection is already possible, consent can be refused by the data subject now, so that it is like a withdrawal of the existing consent. Now, whatever necessary interfaces are to be created, it has to be created by the particular equipment person, and it should be machine readable. And in the case of web browsers of organizations which are not SMEs, like the large organizations, they also should provide technical means to allow data subjects to give consent and refuse a request in an automated machine readable means. This may affect the cookie consent methodology. Then amendment number 16 says that AI processing may be permitted under the legitimate interest basis, where the processing of personal data is necessary for the interest of the controller. Then this legitimate interest can be used with appropriate documentation. The exceptions are still there where there are overriding considerations of freedom of speech or something like that, or if there is any specific law. But AI processing comes under legitimate interest. Okay. So these are some of the changes which have been brought into the GDPR, which we need to keep note of. We will watch out when this becomes actually effective. Thank you.